Good afternoon, everybody. My name is Marty Choate, and I'm Associate Counsel here at the Local Government Commission. This is one of the first of the Local Government Commission's new education initiatives. From time to time, we're going to be bringing in speakers who are knowledgeable on different subjects and topics that are not only timely, but very interesting to the folks who work here in this building and the dome next door. This one is the Municipalities Planning Code and Land Use Ordinance. It's a briefing on the elements of law and the practice important to pro-housing bills. Before I introduce our speakers, just a few quick housekeeping notes. This is a lunch and learn. It's a bring your own lunch, so please feel free to eat during the presentation. We also have some snacks and beverages out in the hall. Please feel free to get up and help yourself during the presentation. For those not familiar with the building, the restrooms, the men's restroom is to my right in the stairwell. The women's restroom is down the hall in the stairwell to my left. This is accredited for continuing legal education for any attorney in the room. If you didn't grab a form on the way in, grab it on the way out, fill it out and drop it in the box, and we'll see to it that you get your CLE credit. This is accredited for 1 hour of substantive CLE credit. The presentation is taking place online and it will be available for viewing via the Local Government Commission's website. And with all those housekeeping details out of the way, one other one, Dave Green, our executive director, wanted to be here today, but he had a family emergency, and so he sends his regrets in that regard. Our presenters today are Denny Kuko and Ed LeClaire. Denny is the owner of Denny Kuko Planning Consultant Services. He's formerly the Planning Program Manager for the Governor's Center for Local Government, connected to the Department of Community and Economic Development. Did I get that mouthful right?
Sounds good.
Okay. And Ed LeClaire is the Planning and Community Development Director for the Borough of State College. And without further ado, turn it over to you, Ed.
Thank you, Marty. All right. Good afternoon, everyone. Thank you for having us. Thank you to the Local Government Commission for asking us to come and give what we hope is a good primer related to the state enabling legislation. So what we'd like to do today, sort of three main objectives that we've got related to the presentation. First of all, we wanted to build a sort of level or foundation of knowledge related to the Municipalities Planning Code, which is the state enabling statute in PA for planning. And we're doing this in terms of relationship to sort of pro-housing bills. So the second part of the presentation is kind of go through a little bit about how zoning is changing and how a lot of the work related to drafting legislation for pro-housing, how that's interacting with the MPC. And we're going to go through some case studies in terms of language that's been in some of the bills that have been introduced in this past session. And then third, kind of wrap up a little bit of a discussion of capacity at the local level and how the work being done in the legislature on pro-housing is going to sort of how that might be rolled out at the local level. So I should step back for one moment and just say, while I'm the planning director in State College, I have a little different hat on today, and that is I'm the legislative chair for the legislative committee for the American Planning Association, our Pennsylvania chapter, and both Denny and Kim Wheeler's in the room are both on that committee as well. So our objective in the work that we do with the chapter is to try to help legislative staff and members understand how the work that you're doing in the housing space could actually be implemented at the local level. We're always looking to say, okay, how will this legislation really work? And how do we make sure that if there's things that we can help you draft and amend so that it will actually play out on the ground and get the results that you're looking to get? That's where we see our role. So keep that in mind as we're talking today. Is our goal is really to try to help make sure that when there's bills being drafted, that they really get to housing supply at the local level. Does that make sense? Okay. So moving on. So the reason that we're here today, and Denny's going to introduce himself when we get to his section. The biggest reason that we wanted to be here today is recognizing that we are in the middle of, I think we can all say, a national crisis when it comes to housing supply, and also making sure that we have housing in the right places. And I think this is something that we're all wrestling with. I wrestle with it as a local municipal planner in State College. We've spent the last 4 or 5 years trying to change our local zoning ordinance to encourage more housing supply. And when you look across the board, not only nationally, we haven't built enough housing, but in Pennsylvania, this is referencing a report from a group called Up for Growth, which does a lot of work on sort of underproduction, looking at how many housing units we're not building nationally in the state. We're about 97,000 units behind where we should be at this point. So There's a lot of effort, and we've seen a lot of bills come out of the legislature in the last two sessions now related to this issue. Where we fit in the planning world when we're talking about this issue, because housing is a wicked problem. It's not something that there's a silver bullet. If there had been, we would have done it by now, right? So we recognize that there's a lot of work to be done on a lot of different areas. And so when you think about why do we have a housing crisis, it's about labor, it's about materials, and it's also about the land, and that's where we think about the regulations. So a lot of what Denny and I do is work with municipalities to set the table to make sure that the regulations are in place so that housing can be built. So when you think about all of the aspects of this problem, what we want to talk about today and focus on is the zoning and the regulations related to land use that will allow for housing to be built. And we're not alone. And so that influx of new legislation that we saw in this last session, we're seeing that across the country. So this is just a brief map to show you all the states that have passed major legislation or multiple bills just in this past 2-year cycle in the states. So we're white right now, but I have no doubt that over the next couple sessions, we'll see legislation likely get adopted. And so what we want to do is be there to help as that process moves forward. So with that, I'm going to turn over to Denny, who's going to walk through some of the NPC aspects, and then I'll jump back in later.
Okay. One of the things that we want to do is encourage you to ask questions. I mean, we think we have a number of things to present and talk about that are going to be relevant and interesting. But if we fail, if we miss something that's on your mind, again, something that you might be thinking about, if you're involved in drafting legislation, something that has been drafted or something that maybe you're looking at, don't be afraid to just stop and ask a question of us. This is what we're here for, in part to be able to get as much information out to you as it would be beneficial and useful. A little bit more about my background. I guess first of all, Ed didn't mention, he also is formerly a planner with DCED's Local Government Services, as was Kim Wheeler. And we mentioned earlier, we outnumber the two that are here now that are the current employees. The former ones outnumber the current ones.
Just here.
Yeah,
right. There's more of you out on the screen.
Yeah, I got it.
And my background also includes 27 years in county planning. I was director in Mercer County and worked 25 years there, also worked a couple years in Jefferson County. So like Ed, I both have experience in the trenches and experience in working at the policy level with the Commonwealth. So the municipalities planning code, we want to talk about the planning code and things that are core aspects about it, that are key, that are important to teeing up legislation on pro-housing bills. And probably the first thing to mention about the planning code that's significant is that it is an enabling law. It delegates power. The state has chosen to not itself conduct zoning or regulate development. It has chosen to pass that power on to local governments. It delegates that power. It provides the authority for the local governments to do zoning and planning kinds of things. It itself is not state administered regulations. So again, the powers passed down to municipalities. They administer the powers that are delegated to them. There's not a role. You won't find in there a place where it says the DCED is the administrative agency for implementing this act. It doesn't say something like that. It's going to pretty much totally delegates the authority down to the local level. Here's a sample of what the typical language looks like. These are two of the ordinances that we'll talk about today, but it's a grant of power. It's basically the way it reads. Subdivision land development. The governing body of each municipality may regulate subdivisions and land development. The second one, general powers. The governing body of each municipality may enact, amend, and repeal and zoning ordinances to implement a comprehensive plan. So it's a grant of power to the local governments. A couple of aspects of this that I think are interesting is that it's may. You see the language up there is may. So it's not mandatory in terms of the grant of power or a zoning ordinance or a subdivision ordinance or a grant of power to do some other things Transportation impact fees are in the planning code. Official map ordinances are in the planning code. Again, the power is a may. In every instance but one, there is one instance where it's a shall, and it's going to be a little quiz. Anybody have any inkling of the one shall in terms of the powers of the MPC? Comprehensive plans, counties shall adopt a comprehensive plan. At the municipal level, city, borough, township, it's your choice to choose to do planning and to adopt that plan. It's your choice to choose to do zoning or subdivision and land development ordinances. As you see, in the interest of advancing the cause of your municipality, it's a may. It's an optional thing. Now, there are aspects of that that the legislature has said must be done. Once you have chosen to enact a zoning ordinance, the legislature has come back and said, well, you may not unduly restrict the display of religious symbols. You shall provide for no impact home-based businesses as a use by right in all residential zoning districts. But those shalls only appear after you've chosen. You've had the discretion to choose as a municipality to enact something, then that choice is yours. Municipality, as defined in the MPC, all classes, city, borough, township, and county, with the exception of Pittsburgh and Philadelphia. Okay. I don't know if any history about how that was done. Those municipalities, there's a site in the DCED publication on local land use ordinances. Boy, it's really interesting to cite the statutory authority for Philadelphia and Pittsburgh, but they do have separate and distinct statutory authorities for planning and zoning and local development regulation, land use regulation. Every other municipality, including expressly in the MPC, home rule municipalities are following the MPC. One other interesting note, I like to go back and I found in doing some research while I was with the state, found a letter that was written from Irv Hand at the State Planning Board. The MPC goes all the way back to 1968. Pennsylvania State Planning Board was instrumental in developing the MPC. And in the 4 years of development leading up to its enactment, Irv Hand, who was the executive director of the State Planning Board at the time, wrote a letter to then Governor Scranton in touting the bill, and he touted two things in it. And those things are still present to this day. One of them is the discretion of the municipalities to do these things if they believe they're right and good. Okay, so a municipality can choose to zone, choose not to zone. The second one is that the essential powers of zoning, subdivision, land development, comprehensive plans are vested in the elected officials. At the time, there was a lot of thought that we needed an independent blue ribbon panel to be more in charge of this stuff. And Pennsylvania said, no, we're going to put it in the hands of the elected officials. We believe that's right and good. And those are the two things that were emphasized by Irv Hand in his letter to Governor Scranton. And those are still true to this day, and they're significant to this day. The enabling law, in addition to providing that grant of power, then goes to say, well, now here's purposes. You're going to do zoning. There are some statutory purposes that zoning must serve. There's content. There's a certain content of what should be, what must be in your zoning ordinance, what may be in your subdivision land development ordinance. It's more on the may side. There are procedures for how the ordinances are enacted, and there are ground rules for administration and enforcement. And again, these things are all part of the enabling what the municipalities are enabled to do. All right, so we got our first case study that we want to take a look at is actually a section that exists in the current municipalities planning code, section 621. And what it reads is that a methadone treatment facility shall not be established or operated within 500 feet of an existing school, public playground, et cetera, et cetera, et cetera. So again, given what we just talked about with the MPC being enabling legislation, does anybody see something that's problematic with the way this is written? Anybody want to volunteer a suggestion? What looks problematic about this? John?
It's a prohibition.
It's a regulation. It's written as a regulation. If it were to be done within the context of the enabling law, what should it have said?
Okay.
Or it probably should have said municipality, the content of municipal zoning ordinance, in their municipal zoning ordinance, a municipality shall do this within the framework of a municipal zoning ordinance. I don't know how many municipalities scratched their heads when this came out and were unsure what they were to do with this, since it didn't say that this was now to be an element of content of zoning regulation. It just established it as a rule from the statutory level. It created a lot of confusion. I don't know, did State College ever build this into the zoning ordinance
They were
anywhere?
doing, then when it got struck down, they actually didn't adopt.
Okay, so the other part of this story is that eventually it was struck down as being struck down by the federal courts as being contrary to the Americans with Disabilities Act. And it's actually really unenforceable, even though it still stays in there. But again, the problematic side of this is that it wasn't written within the context of enabling local governments to do this. It was written as a state regulation, created a lot of confusion on what municipalities were to do with this, what kind of backing they would have if they did implement this in their zoning ordinance. Another important aspect of the municipalities planning code in Pennsylvania is that Pennsylvania is a Dillon's rule state. And Dillon's rule basically says that a municipal corporation has those powers that are given to it, and only those powers that are given or delegated to it by the state. And it basically says those granted expressly, those necessarily or fairly implied, and those otherwise essential, i.e. indispensable, are powers that a municipality can carry out. So again, the question here is it basically calls for care in drafting of legislation so that the language is, clear and that it's providing an express authority to do something, or it's providing, again, pretty strong implication for something to be done. It's important for any language with regard to pro-housing to be done that way. And here's an example of this one. So we're asking the question, one of the areas in which there is some discussion occurring is if there should be a requirement for what's called inclusionary zoning for housing. Anybody familiar with inclusionary zoning? Okay, as a concept, you see an example right there. What inclusionary zoning can say, if it's implemented, is that a new or renovated housing development must include a certain percentage of housing that's affordable, that serves people of lower income. And in this example, there's a 10% number. There are some numbers in terms of what is affordable. And this is a sample of what inclusionary zoning could look like. So the question is there authority? May a municipality in Pennsylvania enact inclusionary zoning? So if we're following Dillon's rule, let's take this from the perspective of, let's say your municipality has been bold and you've just enacted those provisions. You require 10% of a new housing development to be affordable. And you've set the parameters for what's meant by affordable. The developer has challenged you. You're headed to court. What's the court going to ask? The court's going to ask a couple questions. Is there, thinking Dillon's rule, statutory authority for zoning on the basis of the cost of housing or the income level of the occupants of the housing? And here's what the MPC says right now. And it's not everything on the screen here is what's within the content and the purposes, but I pulled out the ones that are most relevant with regard to housing. So the MPC says a zoning ordinance can regulate the use of land, It can regulate the density and intensity of the uses. It can do some special kinds of regulations, protection of natural, historic, agricultural resources. The purposes of zoning are listed there and how they relate to housing. The general promote health, safety, and welfare, coordinated development, reasonable growth, prevent overcrowding and congestion. And here's the last one where the MPC is fairly specific with regard to housing. There is a purpose that is stated this way: to provide for the use of land within the municipality for residential housing of various dwelling types, various forms of housing, various types of housing, single and two-family dwellings, a reasonable range of multi-family dwellings, and various arrangements, mobile homes and mobile home parks. So let's go back to the question. Again, given what's written here, do you believe a court would say there is statutory authority, either express, implied, or essential, indispensable, to regulate housing on the basis of the income of the occupants or the cost of the units? Pardon?
Implied,
Implied in what? In the fact,
allowing for a reasonable range of multifamily mobile homes and mobile home parks.
okay,
They're saying something without saying something. They probably have a legal reason for being able to do that or doing it that way, but there's no express income-based language there.
all right. So if Pennsylvania does have a strong litigation history in supporting the development of multifamily housing, particularly in Southeast Pennsylvania, there have been a number of cases where the court has said your municipality's got to accommodate a fair share of multifamily housing, but it hasn't specified that the housing has to be affordable. The courts haven't specified. Is it implied here? Anybody else have an opinion? I think it's a question that we have wrestled with. And there's a couple municipalities, I believe. I don't know if there's even a handful, 5 in Pennsylvania, that have done inclusionary housing that are under the MPC. Pittsburgh has done inclusionary housing under their own enabling legislation, which I think is broader than the MPC. I'm not sure what Philadelphia has done.
There's a couple districts.
Okay.
Zoning overlays with zoning requirements.
Okay. But under the MPC, there's a couple, I don't know, if I would have to wager 5 at the most statewide that have ventured into this.
And I should point out, State College is one of those, and I'm happy to talk about that after the session, if anybody wants to get in further detail. I didn't want to take time on it, but we have been bold, but we've not been sued. So until we're sued, we don't really know.
Do the courts give, when they're looking for implied powers, do the courts say it's to be liberally construed or narrowly construed?
I would think the courts would lean more narrowly.
Well,
Well,
then narrowly,
Yeah.
One supplement I would give is that you enjoy a presumption of lawfulness
Okay,
from the enrolled bill. So you do start with your runner halfway to first, but I'm it's my call on this is that I kind of agree with Sam that I think you have a pretty good basis for an argument in that third bullet point under 604. Especially since Dylan's rule is not typically interpreted narrowly.
okay,
Maybe if I could just say one thing too. So this is an example where you may have 2 statutes, because as a home rule municipality in State College, we have viewed the authority provided to us through the home rule statute as giving us some additional broader authority. So our solicitor has been comfortable with the adoption of that mandatory inclusionary housing because we're home rule. If we didn't have our own charter, which specifically discusses provision of housing, then we may not have adopted that ordinance, or elected officials might not have adopted. So another thing to think about is that now we've got 2 statutes that we're looking at, and how do they interrelate? So just
Yeah.
to muddy the waters even further.
yeah, and that would be interesting because, again, as I mentioned, the municipality's planning code is expressed in saying that it applies to municipalities under home rule. So, what would apply there? I guess the bottom line is that something that is more express and clearer in providing a statutory authority for inclusionary zoning would be helpful in this case. Is it needed? We wouldn't find out till we got to court, I guess. But, you know, to be helpful, to make that municipalities more clarity and confidence to proceed with something like that, a more express provision that relates to either the income of the occupants or the cost of the units would be potentially beneficial. So let's get into the municipalities planning code provides the enabling authority for what are called land use ordinances. And there are two primary that we're looking at here, subdivision and land development being one and zoning being the other. There's also an ordinance called an official map ordinance, but we won't get into that today. But it is one of the other land use ordinances called out in the planning code. So I think most of you are probably familiar with a zoning ordinance. It looks like the map on the screen. It divides the municipality into different zones within which certain uses are permitted and others are not expressly permitted, and within which there are requirements set on density of the development, the intensity of the use. It gets into other things that are maybe more ancillary to development, performance oriented, like parking and signs. It gets into things like even regulating landscaping and lighting and noise. So there are a number of things that zoning gets into, but again, the core part of it is that it allows the municipality to define those within areas of the municipality, uniquely and differentiated areas within which uses and intensities of uses are permitted. The subdivision and land development ordinance similarly deals with the control of development, but it does not deal with the location of the development. It says, okay, you're permitted in this location. Once this use, say housing is permitted in the R2 district, now here are the parameters, the criteria, and the standards under which the development of that housing shall take place. The subdivision land development ordinance regulates subdivisions, regulates land developments, regulates a lot of other types of improvements that are associated with those, from the construction of roads and water and sewer services that serve these developments, and the provision of things like sidewalks, dedication of land for rec facilities, are things that are regulated within the sphere of a subdivision and land development ordinance. Now, and these are, I think most of you probably basically understand these, but I guess I'm going to pause and ask if there's any questions about these two primary land use ordinances, what they are and how they're distinct. And again, the MPC says the municipality has been granted the power to choose to enact either or both of these. If they do, here's your purpose, here's your content, here's how you enact it, here are some rules for administration enforcement.
So the related improvements for streets and stuff like that, it would not be in the zoning ordinance, it would be in the subdivision land development ordinance. Like parking is not a related improvement or anything. Parking would be in the zoning, signs would be in the zoning, rather than just like use type. It seems like a little incongruous that they would be in two separate places for some of those, like, if you do go through this use, here how it looks is in zoning, but then also in the land development ordinance too.
When you get to what I call up on the next slide, regulation of certain features of development, it can appear in both ordinances.
Gotcha.
It wouldn't appear in both for a municipality that has both, but a municipality that maybe has a zoning ordinance, but does not have a subdivision and land development ordinance, probably beefs up a little more in terms of performance kinds of standards and development kinds of standards in its zoning ordinance. Maybe there's a lot of municipalities that have zoning, but they rely on the county subdivision land development ordinance for subdivision land development. Beef up their zoning ordinance. Conversely, there are municipalities that don't have zoning, but have
either or municipality.
Yeah.
Choose both.
There's an attorney that once said If I'll go to court and I'll defeat a zoning ordinance that is overly restrictive in terms of these development kinds of regulations. I think they belong in Saldo. But I don't know that that's ever been challenged. And they appear, like I said,
A lot of municipalities will have both ordinances.
right.
But there may be design standards in the Saldo, like, for instance, curbing. So I've got a parking lot, the standards of laying out the parking lot is in the Saldo. The number of spaces I need to have by the use is in the zoning. Thanks.
Yeah, I would pretty much clearly say that the construction of the infrastructure is always in the Saldo. I don't believe, I don't know, could a street be regulated as a use?
Should be.
Yeah, it wouldn't be regulated. There wouldn't be a requirement that the proposal to construct a street gets a zoning permit. It's typically part of the plan of development. The street, the water and the sewer, things like sidewalks that go with it are typically, but when we get into some of the performance things, lighting, landscaping, noise, parking, those things appear in either or sometimes. Again, the impact on housing, zoning is more on the location, where it's permitted, at what densities. Is there one district that's primarily single family, another district that's primarily multifamily? The subdivision ordinance is more on the creation of the lots on which the housing might be built. And then again, the submission of that plan of development and the review of that plan of development that would possibly have housing in it. A couple of keys, again, on the zoning side, there is the stated purpose in the MPC. That's important. And again, as we're drafting something in a housing bill, we've got to go back to that stated purpose and remind ourselves that on the subdivision side, a single family housing is not regulated as a land development. Okay, only when you get into multifamily housing is it regulated, but single family housing and the cost of it is impacted by what kind of requirements exist for water, sewer, and roads. Okay. Ed's going to talk about the practice, the changing practice.
All right, so State College's base zoning ordinance was adopted in 1959. It's been adopted over 220 times. Yes, we did go back and count. That was tedious. But at the end of the day, we're a mix of evolution. And when you work with other municipalities, when you're drafting legislation that's going to affect, and Denny's going to show you how many of those municipalities later, you be thinking about the fact you have a whole range of age of those ordinances, and they're structured. There's an evolution of the practice that has happened over time. So Euclid versus Ambler in 1926, this is the Supreme Court case that enables or allows local governments to essentially zone uses and to sort of regulate land use in municipalities. So that created entire decades of ordinances that are what we call Euclidean in nature. And that means that they're based on the idea of segregating uses, because Euclid versus Ambler was really at its heart about segregating residential use from industrial use. They didn't want to have smokestacks next to single family homes. Now that was in the 1920s. Things have evolved. The United States has changed quite a bit. And so what we've seen is when you're thinking about how this might be implemented locally, when you're thinking about writing legislation, realize that a lot of ordinances you might run into have evolved from that Euclidean structure. I still work in a municipality with a very Euclidean structure. I'm going to show you that in a minute. But we've also evolved to a point where there's a lot more mixed use, a lot more ordinances that say, yeah, we actually don't need to keep all residential over here and commercial over here and industrial over here. You're seeing a lot more integration and multiple uses. And also we've started to see an evolution of moving away from just the use as the focal point and more to form. Because we want to make sure that what gets built fits into the fabric of the neighborhoods, fits into the fabric of the commercial districts, and that we can start to regulate more about what gets built, how it looks and fits in, and less about it just being about the use itself. So a typical zoning ordinance in Pennsylvania today is going to have a permitted use or principal land use table in it. Now I have seen, this is, Denny, where's this one from?
It's fictitious.
This is fictitious. Excellent. We're doing some fictitious. So, but what you see there is Up at the top, you've got the uses as permitted, and then to the right, you've got the different zoning districts. And so what you'll see is a list of are these uses permitted? Are they a conditional use? I'm going to talk about that in a minute. Or are they potentially a special exception, which is another way of being a permitted use, but requires a public hearing, and the approval or the conditions are then applied by the zoning hearing board. A conditional use is done at the governing body level. So what you'll see is, okay, here's all the uses that we're permitting. Is it something that's permitted by right? And in Pennsylvania, a permitted use by right means a zoning officer is essentially tasked with a ministerial approval. There's no hearing, no governing body involved, no zoning hearing board involved. This is done at the local level. Now, other ordinances that are really old, like mine, are in more of what we call the Euclidean method, which is the very bottom of this pyramid. It's sort of recent. So when you hear people say things like up zone or down zone, who's heard that phrase before? Sam, I know you have. So at the end of the day, it's actually, they're reversed, but a lot of people will say down zone, meaning that's going to reduce the amount of density or intensity of the use. And when you look at this, and you'll sort of see the least intense, limited to sort of one family, two family, you start to see that as you move up the pyramid, you get more intense of uses, and all the way up to what is typically in a Euclidean zoning district or zoning ordinance thought of as just unregulated industry. So just keep in mind that when you're drafting legislation, these are two sort of different ways that you're going to see a lot of ordinances structured. But at the end of the day, what they're doing, the third one being ordinances where you'll start to see a regulation of the form. So at the top, you're going to hear phrases like the transect. I'm a geek, and as a planner, we're nerds. We like to use, first of all, we live in acronyms. So if we do say an acronym that we haven't explained, let me know. But the transect is the idea that there is a intensity and density of use and form that as you go from your most natural rural zone all the way up to like an urban core, that trying to develop ordinances that are kind of regulating by that intensity of the building form, and then trying to match to the existing kind of urban character or rural or natural character of the municipality. So you'll see these as well. An example, I think this is Brookville in the lower right-hand corner. That was built in 1995.
Yeah.
And so this is, it fits in. And so you're going to see regulations that are built in. Hey, how do we make that building fit in? The uses are not as prescribed as it is the form.
And you're gonna actually see that in zoning ordinances more and more. You're gonna see again a T1 or a T2 zone as opposed to the old school R1, R2, B1, B2.
And so this is an example. We're going to start doing a couple case studies on some of the bills that were introduced in this last session. So House Bill 1976, this was a focus on permitting multifamily units or multifamily construction within commercial zones. So the reason that we want to bring this up today is because Easton Borough is sort of used as an example. When we say a commercial zone, you could be dealing with a municipality that's got a whole series of mixed-use zones. When we start to say, well, what does that mean at the local level? It's got to be permitted in a commercial zone. There is over 10 different zones that may meet that definition. So giving some guidance, and by the way, I should also say, as we're doing these case studies, our goal today was not to go through and say, well, here's what the right language should be. What we wanted to say was, these are things to be thinking about while you're drafting. And we've been working at the APA level to sort of look at some definitions and some other things that we could provide as assistance. But the purpose today was to say, be thinking about the complexity that you're going to run into when you're writing legislation. So just saying it has to be a commercial zone and can't be in an industrial zone, how a local municipality is going to interpret that and implement it at the local level gets incredibly complicated. Are we talking about them permitting that in an institutional zone, which could be your hospital zone, for instance? It's commercial. Do we want single family homes built in a hospital zone? Just things to be thinking about when we're drafting. So I just talked a minute ago about permitted and permitted by right uses. So especially when we're dealing with legislation that would be a requirement of a local municipality to enable something or to actually be required to permit it. We have different ways of permitting at the local level. And so what this is just a brief way of sort of showing all the different hearings, all the different places where there might be review. So when you've got a use by right, that is the simplest thing from a approval standpoint. So when we're talking about a preemption bill that might say a local municipality, you must permit this by right, it means the zoning officer signs off on it. There's no governing body review. There's no zoning hearing board review. Nobody looks at this except a man or a woman behind the table who's looking at the permit and saying, yes, I'm to approve this. When you're talking about conditional use, it's a permitted use by right, but it requires a hearing at the governing body, and the governing body is permitted to apply other conditions to it. Special exception, same thing, except the zoning hearing board, not the governing body that does it. So this just gives you an idea of the complexity of all the different places of review. You may have a county review, you may have county review of the subdivision land development or of the zoning enforcement itself. We do have some counties that have countywide zoning too. So
An important part of this is not so much remembering what this chart looks like, but understanding again that the statute does define these roles and does set timelines associated with these as well. A hearing must be held within X number of days. A decision must be rendered within X number of days. So again, as the legislature would be pondering legislation on how housing might be implemented differently, it should fit, acknowledge the context of these, work within that, build on it, this statutory context of these approval processes.
and just to give an example of that, this was in House Bill 2045. So you see in the very beginning, it says that the local municipal ordinance must allow multifamily housing as permitted, as a use permitted by right where a single family home has been permitted. Very clear to be permitted, right? But then it goes on to say that the municipality could petition the county or a regional planning agency to review the proposed development that's permitted. And then on top of that, it gives an agency, which by the way, isn't clearly defined. Which agency are we talking about? Is it the county agency or the regional agency, or is it the local planning agency that could then require infrastructure capacity to be built? So the legislator said, we want this to be permitted, but then it also provided an off-ramp for municipality to say, no, there's actually other agencies that have to look at this. They have review. They also can even ask for additional infrastructure to be provided. That's a long, far way away from a man or woman behind a desk saying, yes, I'm permitting it. Does that make sense? So these are the things to be thinking about when we're drafting. Is there value in making sure that there's infrastructure? Yes. How do we get there is part of the issue to be thinking about. But this is a situation where you've got sort of two conflicting paths that are happening in the same statute. This is 1126, this is the Santo bill. In this case, it's written very clearly in terms of that there is a permit application for an accessory dwelling unit. So this is usually a secondary unit built on a principally residential lot, and is saying that it has to be approved ministerially. So this would be a zoning officer. I would interpret this at a local level as my zoning officer would then have to approve a permit application for an ADU, accessory dwelling unit. And the other thing I wanted to point out was this, Denny said the MPC is only for non-Philly, non-Pittsburgh. Well, this was clearly drafted to say, no. This is going to preempt every municipality in Pennsylvania because it's included first and second class, first being Philly, second being Pittsburgh. So what you have here is a legislature saying, yes, we're going to ensure that we're going to require local municipalities to permit ADUs, not just in the MPC, but also for Philly and Pittsburgh. And so, the last thing I want to draw your attention to, which we're going to talk to at the very end, is it's also giving a time frame for that ministerial approval of 14 days. Just wanted to point that out. We'll talk about a little more about that in a minute.
One of the really interesting aspects about the MPC, and I got this question frequently when I worked at DCED, is there's timeframes for rendering decisions on land developments. There's timeframes for holding hearings. There is no statutory timeframe within which a zoning officer must render a determination to approve or deny a permit.
So a lot of times that zoning permit's tied to the land development. So we call them shot clocks, at least I do in the profession. So I will also tell you, just as a kind of point of information, when I work with my counterparts, their ledge chairs in other states around the union, I've been surprised that Pennsylvania actually does a decent job in having those timeframes. There are other states that actually don't have nearly the compressed timeframe we do, but we're inconsistent in sort of how all those fit together to make sure that the development gets done in a timely fashion. So we do have a 90-day review requirement for land development. We don't have a requirement for a zoning permit. In our office, we run sort of a 30-day, like our standard is we want to make sure that that is approved within 30 days and it's out the door. We'd like to be faster, but we really kind of give ourselves that lane.
Did the borough write that in the ordinance?
No, it's just,
Administrative.
it's my preference as a manager, basically. So, a couple other things to be thinking about. We got about 10 minutes left, so I wanna go fast, but a couple things that you should be also thinking about when drafting. The MPC has a specific section, section 107, that lays out definitions. So these are statutory definitions. So at a local level, the rule has always been, if the MPC has a definition, we should adopt that in our own local zoning ordinance. It kind of one ring to rule them all as far as the definition goes. But if there isn't, we're on our own. We've got to come up with what we want to have in our own definition. So point of information. A lot of the statutes that were proposed, a lot of bills that were proposed, don't define dwelling unit or haven't defined dwelling unit. A few of them have, but some of them haven't. Dwelling unit isn't defined today in the MPC. And so the thing to be thinking about is when a bill is drafted and says by dwelling unit, if that's not defined, there are ways that local municipality may then tinker with how that definition is going to be done. And that is going to affect how those housing units get built, especially when we start talking about duplexes, triplexes, and quads. So the idea here, this was a definition that was written into, I think this for copy, this is the smart growth zone legislation, it's 2515. The idea being, this is a relatively straightforward dwelling unit definition. Another thing to think about is there was a case study. Again, I don't want to talk about which is the best one, but what I wanted to point out was each of these three definitions of a duplex are in bills that were proposed in this session. They all tackle it in slightly different ways. One is talking about dwelling units by walls. You've got a horizontal or a vertical wall. The second is dealing with it in terms of you've got stories and then you've got occupancy. There's also definitional issues about family versus person versus individual. These are all different terms of arts, but my preference is usually on individual personal, staying away from family. Family definition has some federal issues that go with it. Then also the third definition, you start talking about parcels and lots. So you can see, you put all of these together, and then you also have the issue about independent living among either persons or families or individuals. So again, I think we're doing some work at the APA level to try to come up with maybe a good duplex, triplex, quad, definition that everybody can kind of agree on. But as the different legislators different members who want to bring forward housing bills, these are kinds of things to be thinking about, because if the legislature passes a duplex definition in a bill that says the MPC is going to be this, now all of us who have zoning ordinances, all work in this full levels, we're now going to have to adopt that definition. We're going to have to change the ordinance to line that up. There's a lot of power there. There's a lot of impact there in terms of how this will get affected at the practice level. Last thing to talk about in this section is development standards. So section 603, Denny already pointed this out. This specifically gives municipalities the authority to not just talk about the use, you could also talk about the height, the area, the bulk, how that building is going to get built on the site, where, how tall, how intense. So when you start talking about, especially bills that would preempt a use or would require a municipality to authorize, say, a duplex. Also thinking about the other standards that go with that. How many parking minutes? One of the poison pills, one of the ways that you stop at a local municipal level adopting the accessory dwelling unit bill, for instance, is to suddenly require a lot of parking spaces. Anybody like an English soccer fan in the room? Anybody play hockey, soccer? Okay. All right. Well, I'm a hockey player. I used to play hockey. I know I don't look like it today. But at the end of the day, we call them the dark arts. So these are things you can do in a soccer game, for instance, to slow up the play. Ways that we can sort of make sure that somebody doesn't get the puck. So these are ways that a local municipality, again, I work for my governing body, and my governing body says, whoa, I really don't want accessory dwelling units in our municipality. And go find ways to keep that from happening. So that's my job. I may or may not like it, but that's what I'm tasked to do as a local municipal official. So these other standards are often ways that we might limit it. So a lot of municipalities that have done ADUs, if there's like an owner occupied requirement, for instance, that often will kind of kill. AARP did a really nice piece on all the different things you can do, you should be thinking about when you talk about development standards to make sure that the ADU does get built. So just things to be thinking about when you're talking about drafting legislation.
Okay, just a real quick couple of slides to let you know the landscape that we're working in. Anything that might be enacted that's pro-housing oriented is going to have to deal with this kind of environment. And that is that Pennsylvania, not all municipalities have zoning. Roughly 2/3 About 1,600 have a zoning ordinance of their own, and another 137 are falling under a county ordinance. So there's a lot of municipalities that don't have any zoning at all. That's part of the context within which we're operating. This is the territory in Pennsylvania. The darker shaded municipalities are the ones that do not have zoning. So again, if we're gonna do something that's providing a grant of power, it will reach not everybody. If we're going to do something that is mandatory, if it's going to be done through zoning, it's not going to reach every municipality because not every municipality has zoning. And then I think the other thing that's worth noting is that anything that would have to be done, again, from a zoning standpoint, if it's going to be permitting multifamily in a commercial zone, if it's going to be permitting accessory dwelling units, it's going to have to be done by the municipality taking action to amend its ordinance, to update and amend its ordinance. And here's what you have in terms of capacity in Pennsylvania. You've got places like Allentown that have tons of staff. Really, they have they would tell you they're probably short-staffed. But comparatively speaking, they've got a number of folks on the planning and zoning and housing side. You get down to a city like Greensburg at about 15,000 population, and all of a sudden, here we are. We've got a planning director who's also the zoning officer, and we have a small number of code housing staff on the working for the municipal government. And we get down even lower. The predominant number of municipalities across Pennsylvania are going to be small boroughs and small to medium-sized townships, and they're going to have no planners. They're going to have a part-time zoning officer, a zoning officer who's probably also the borough manager. They're going to have only a secretary. And that's going to be the framework within which anything that's enacted would have to be implemented, administered, and carried out within that kind of limited capacity.
And along with that discussion about capacity, so as legislative staff and members, you're familiar with the sort of typical 60-day enactment language or effective language. From a MPC statute standpoint, when local municipalities that have a zoning ordinance are going to look to amend that, we call it either a text amendment or a map amendment. The statute actually provides timeframes that they have to work within to do that. There's public notice requirements. There's 30-day hearing notice requirements. There is review by county and by planning agency in 30 days. And also, if you make a recommendation, say from planning commission, it's advertised, it goes to the governing body for their review, and they would like changes. Often it gets referred back to planning commission for more review. But even if they just want some changes from what was advertised, you got to do the 30 days all over again. So the thing to be keeping in mind is if the legislature is going to provide timeframes, understanding that you're going to want to see change on the ground, right? You're going to want to see if you adopt a housing bill that's going to, require duplexes, for instance, you're going to want to see that get built on the ground. So to be able to provide the municipalities with enough time. Also, and I know we have DCD staff here, so this is not a commercial for DC support, but at the end of the day, resources for local municipalities to go through these processes, to change the ordinances. There isn't very much money on the street today to go through that to make sure municipalities can make these changes. So we wanted to bring that at your attention is if you're going to be writing bills, give some runway, whether that's 6 months, whether that's a year. But we're also at the local level going to need to have some kind of processes with our own residents to make sure that we are informing everybody about what these requirements are, and we're going through an appropriate sunshine oriented whole process. So just something to think about. You remember back before on the one House bill, there was the 14-day requirement. Kind of to Denny's point, as far as the lack of capacity, well, that part-time zoning officer that might be doing 3 municipalities, 14 days is probably not enough time. So just, again, you want to see the change on the ground, but we wanted to kind of bring the reality to the table as far as what you've got, capacity at the local level to do these things. So I think with that.
And again, a quick 30-second note that to play this out is if there is a bill enacted that requires municipalities to accommodate accessory dwelling units. Municipality doesn't act. 3 years go by. Somebody comes in, they challenge the fact that they can't get an accessory dwelling unit on their property, that goes to court. That's how that would be enforced. That's how that law would end up being enforced. It would go to court. The court would say, oh, your ordinance isn't valid because it doesn't accommodate accessory dwelling units like HB, whatever said it had to do. That's how that would have to play out unless some other alternate could be conceived. Anybody familiar with the acre law? In Pennsylvania, the acre laws are related to agriculture. It uniquely provides for the state attorney general. State attorney general to step in and say ordinances are overly restrictive and constrain agriculture in an unreasonable way. Instead of requiring it to go to the courts, it's given the power to the state attorney general. So that's part of what needs to be thought out, how this would be implemented and enforced from a statutory level.
All right, we just got a couple minutes left. First of all, thank you for your attention. Thank you for the time. Any specific questions? And Danny and I are obviously going to hang around afterwards, if there's anything specific. I'm definitely happy to talk about mandatory IZ since I live that every day. So. Okay, well, Marty, Chris, thank you.
Ed, Jenny, thank you so much for your time today. It was an incredible presentation. I learned a lot, took a lot of notes, and we'll have to have you back for more. Thank you so much.
Thank you. And we have some parties to go
Remember, any attorneys in the room, want to see a late plan, stop and form off in the box.
I'm going to put you out in the back.